What's up, everyone? This video is going to be a little bit different. We're going to discuss something known as the Rooker Feldman Doctrine. This is something that's very relevant if you're trying to pursue claims in federal court while you have litigation active in state court, or maybe your state court proceedings have ended and you're trying to raise a claim that's somewhat relevant to that state court proceeding. Now, what is the Rooker Feldman Doctrine? Well, first, what is a doctrine? A doctrine is a set of beliefs, essentially. The word comes from the Latin doctor for teacher, so think of a doctrine as the teachings of a school, religion, or political group. In this instance, it's widely used in the legal system to reiterate a set of beliefs held in a specific circuit or group of circuits or the U.S. Supreme Court, so on and so forth. Now, the Rooker Feldman Doctrine is a judicially created doctrine that strips federal courts of jurisdictions over certain matters that have been decided by a state tribunal. The Rooker Feldman Doctrine finds its roots in the full faith and credit clause of the Constitution, as codified by Congress, and the full faith and credit statute. Under the full faith and credit statute, federal courts must give the same preclusive effect to state court judgments that the judgments would be given in the courts of the state from which the judgment was entered. The doctrine takes its name from two Supreme Court decisions that were rendered 60 years apart from one another. In both cases, plaintiffs sought to challenge in federal court the decisions of a state court tribunal. The two cases that this is referring to is number one, Rooker versus Fidelity Trust Company, 263 U.S. 413 in 1923. Then we have the District of Columbia Court of Appeals versus Feldman, 460 U.S., page 462, 1983. In Rooker, the court held that no court of the United States other than this court, referring to the Supreme Court, could entertain a proceeding to reverse or modify state court judgment. In Feldman, the court reaffirmed that the United States District Court is without authority to review final determinations of the District of Columbia Court of Appeals and judicial proceedings. So, key thing to keep in mind here is final determinations. Now, the application of this doctrine. Because of the Federal Circuit's inconsistent application of this Rooker-Feldman doctrine, the United States Supreme Court granted certiorari in ExxonMobil Corp. Versus Saudi Basic Industries Corporation. In this case, a foreign corporation owned predominantly by the Saudi government sued two ExxonMobil subsidiaries in Delaware Superior Court seeking declaratory judgment. About 2 weeks after the Saudi corporation filed suit in state court, Exxon countersued in federal court, invoking subject matter jurisdiction under 28 U.S.C. 1330, which authorizes federal courts to hear claims against foreign states. The Saudi corporation moved to dismiss the federal action, which the district court denied, and filed an interlocutory appeal. During the pendency of the federal action, Exxon won a judgment before the state tribunal. Now, the appeal. On appeal, the Third Circuit considered whether the federal court had subject matter jurisdiction under the Rooker-Feldman Doctrine because Exxon's claims had already been litigated in state court. Exxon argued that Rooker-Feldman could not apply because it filed its federal suit before the state court judgment was rendered. The Third Circuit rejected Exxon's argument and concluded that such an interpretation of the Rooker-Feldman Doctrine would be encouraging parties to maintain federal actions as insurance policies while their state court claims were pending. Accordingly, the Third Circuit held that once Exxon's claims had been litigated to judgment in state court, the Rooker-Feldman Doctrine precluded the federal district court from proceeding. So the thing to note about federal courts is the best thing a federal judge can do is to not do at all. That is their mission, they try to not take cases and limit their jurisdiction to only a specific set of circumstances. Now, the Supreme Court unanimously reversed the decision of the Third Circuit on appeal and held that Exxon's federal action was not barred by the Rooker-Feldman Doctrine. Writing for the court, Justice Ruth Bader Ginsburg reaffirmed the basic principle that the federal courts have original jurisdiction under 28 U.S.C. 1331, and jurisdiction is not impeded simply because there is a parallel state court action. Justice Ginsburg further noted that the doctrine is confined to cases brought by state court losers complaining of injuries caused by the state court judgments rendered before the district court proceedings commenced and inviting district court review and rejection of those judgments. Justice Ginsburg cautioned, however, that principles of preclusion or application of the abstention doctrine may nevertheless permit or require the federal court to stay or dismiss the federal action in favor of the state court litigation. So the impacts of this decision were significant. The Exxon decision has required the federal courts to rethink the application of the Rooker Feldman doctrine to claims that appear to be inextricably intertwined with state court litigation. As Justice Ginsburg aptly opined, if a federal plaintiff presents some independent claim, albeit one that denies a legal conclusion that a state court has reached in a case to which he was a party, then there is jurisdiction and state law determines whether the defendant prevails under principles of preclusion. Now, in McCormick versus Braverman, another case, Judge Clay, writing for a panel of the Sixth Circuit, recently emphasized that the Rooker-Feldman doctrine is not a panacea to be applied, if I said that word right, whenever state and federal court decisions potentially or actually overlap. Essentially, the court must look to the source of injury to determine if a claimant can challenge a state court judgment. Now, the Sixth Circuit has set forth a source of injury test to differentiate claims attacking state court judgments and independent claims over which a federal court may assert jurisdiction. If the source of injury is the state court decision, then the Rooker-Feldman doctrine precludes federal jurisdiction. However, if there is some other source of injury, such as third parties' actions, then the plaintiff asserts an independent claim. This is the source of injury test. In essence, the court's decision in Exxon and the Sixth Circuit's decision in McCormick made clear that the Rooker-Feldman doctrine bars federal review of state court judgments while reaffirming that the federal courts maintain original jurisdiction in parallel state and federal proceedings. However, when a matter is proceeding simultaneously in both state and federal courts, the federal court may apply one of four abstention doctrines and decline to take jurisdiction. The other three, we will discuss at a later date. But this is relevant stuff if you find yourself in legal proceedings. Have a good one.